Every Friday, Colorado's best attorney empowers us with legal knowledge that we can actually use. I have to say, I've thought of you many times, like when I'm driving down the street or something. This is what Phil said. No joke. You do have a lot of great information. Yeah, let's go down your resume because it's been updated.
Oh,
we love the update here. He's been practicing law in Colorado for 27 years, a super lawyer 7 years in a row, voted one of the top 100 trial lawyers in Colorado for 10 years in a row, AV-rated attorney, which is the highest rating you can get, and a member of the million and multi-million-dollar advocates forum. We love Phil. You always have great information. Today, we are going over what percentage of cases go to trial and what percentage are settled. Why should we care about this?
I think it's important for everyone to know, and let's kind of go over some statistics to start off with. First of all, 95% of all cases settle even before the filing of a lawsuit. And then once a lawsuit is filed, the court will say you have to go through a settlement conference. It's called an ADR order, which stands for Alternative Dispute Resolution. So I want to talk a little bit about what a settlement conference is. First of all, it is a non-binding thing, which means the parties don't have to settle, but they try to compromise, and you're in front of a retired judge, and this retired judge has seen just hundreds and thousands of cases, so they try to bring the parties together. And really today I want to go into an inside look of settlement conferences.
Okay, so first, what are the statistics of cases settling versus going to trial?
Right, so the first one that I said was 95% even before the filing of a lawsuit, they get settled. Then of the ones that file a lawsuit all the way through trial, 90% of those settle. So really only a very small percentage goes to trial. I want to look at the who, what, when, where, and why of settling. And first of all, when to settle your case. Remember, there are statute of limitations, which means if you don't settle a case or file it before these dates, you could be missing out. And generically, I'm going to talk about GIA here in just a second. But a breach of contract generically is a 3-year statute of limitations. Auto accident, 3-year statute of limitations. Slip and fall, that's a 2 years. GIA stands for the Governmental Immunity Act. And what it means is if you got hurt on a government property or the county assessor runs into you with his car, you have to give this notice. And it's within
180 days.
182 days to get those 3-year or 2-year statute of limitations. Also, I don't want people to settle until after you know all your damages. But you still have to look out for the statute of limitations. So even if you're still treating, you still have to either settle or file a lawsuit before that time frame.
You got it. All right, what's this next? I think we're going to the next graphic.
Yeah, well, look, let's talk about what you need to settle a case. And what you need is you need to have a theory of your case. In other words, you need to describe as to why you're right and know why you're right. And you have to have an elevator speech. If you have a really long explanation of why you're right, you're going to lose that case. If you can succinctly and easily say why you're right and why you should win, jurors love to hear that. Also, you need to know all of your damages, and that's economic losses. So let's just say it's a personal injury case. You need to know your time off of work. You need to know your medical bills. And remember, we talk about this. Your medical bills, all the time, health insurance pays for it, and there's a billed amount and a paid amount. You only show the other side the billed amount, the larger amount. Also, medical records with proper redaction. What I mean by that is, let's say you have medical records that's talking about your auto injury, but it's also talking about, I don't know, a hangnail that you had 3 years ago. That's not relevant. You can redact that. Next, you need to know your risk, and that's what I want to talk a little bit about here, when you know your risk. Look, if you think you're going to win a case absolutely and it's a slam dunk, think again. There are no slam dunk cases. I've won cases that people thought that I could never win. I've also lost cases that I thought I'd never lose. So if you do lose, and again, if this is a personal injury case, you have to pay the other side's costs, not their attorney's fees and their cost. And let me tell you what costs are. Costs are like expert witnesses, filing fees, exhibits, all that kind of stuff. The other thing I want to talk about is I love it when there's a good attorney on the other side, because he and I know, and we've gone through it so many times, that we know the best settlement is where both parties walk away going, man, he thinks that he paid too much. I think that we got too little. There are just so many things. Obviously, you can call me, write me, or talk to an attorney, but settlement conferences are the way to go to get things out. And you can even file a settlement conference or do a settlement conference before the filing of a lawsuit. It's called a pre-suit mediation. It's becoming the trend these days.
Nice. Give Phil a call if you're in this situation. So if you have a question for Phil, our legal expert, go to kwgn.com. Click on Colorado's Best. You're going to see Phil Harding's photo on the right. Just click there, send in your questions, and he will answer each question personally and confidentially. And to reach Harding and Associates directly, call 303-762-9500. You can also get a free consultation anytime, and you can find him online at hlaw.org. We'll be right back.